A very good day I bid to Mr. Muhammad Noor. I am Daniel Panjalan Su, and alongside me are my group members Annabelle, Yasmin, Alisa, and Riyad. Today we are going to conduct a presentation based on the following facts. Dinas, a full-time housewife, was accused for the murder of her husband Nazlan. While they were sleeping, the house caught on fire. The accused, realizing the fire, ran out and locked the door with the deceased still being in the burning room. When the accused had escaped and was safely out of the house, she did not contact the fire department immediately. A security guard came and helped contact the fire department. However, once the fire department arrived, they found the deceased body severely burned and caused his death. Accused claimed that her action was caused by her panic disorder. Therefore, there will be four parts in this presentation in regards to whether Dinas is criminally liable for murder under Section 302 of the Penal Code, whether Dinas charge be amended to an offence lower than murder, can Dinas raise the defence of accident, and can Dinas raise the defence of unsoundness of mind. Now, I shall pass the floor to my fellow group mates to clarify on this matter of discussion.
Thank you, Daniel. Now I'll be discussing the first issue under the first question, which is whether Dinas is liable for the actus reus under Section 300 of the Penal Code, which is causing death. Dinas' act of not making any effort to inform her husband about the fire could constitute an act under Section 33 and is sufficient in the ordinary course of nature to cause the death of Nazlan. Besides that, Section 43 also states that she is under the duty to rescue her husband when she first noticed the fire. Thank you, Daniel. Now I'll be discussing the first issue under the first question, which is whether Dinas is liable for the actus reus under Section 300 of the Penal Code, which is causing death. Dinas' act of not making any effort to inform her husband about the fire could constitute an act under Section 33 and is sufficient in the ordinary course of nature to cause the death of Nazlan. Besides that, Section 43 also states that she is under the duty to rescue her husband when she first noticed the fire. This is because they were sleeping together before the fire broke out and she was the nearest person beside Nazlan. Dinas' act of not waking her husband up, nor did she inform the fire department, and knowing that her husband was inside the burning room, she locked the door, and this constitutes her failure to act under the duty of act equals to an illegal omission. The second issue is whether the causation can be established by proving the but-for test. But-for, Dinas' act of locking the door from the inside had prevented Nazlan from escaping the burning room, and Nazlan would not have died if Dinas made an effort to save her husband from the fire. Based on this principle, Dinas will be liable for causing the death of Nazlan, and causation is most likely able to establish is whether Dinas had the mens rea required under Section 300 sub B of the Penal Code, which is mens rea intention when she was committing the actus reus. By applying R against Nedrid case, Dinas had admitted that when she saw the fire, she acknowledged that if she left her husband long enough in the fire, it would have killed him. So therefore, Dinas had foreseen and know the consequences of the small flame. That's why she left the house. The failure to inform Nazlan about the fire and lock the bedroom door from the inside amounts to an intention of causing death to Nazlan. Besides that, applying Muhammad Haikal bin Muhammad Khatib Sadali against public prosecutor case, not only did Dinas left the house, she also prevented her husband from escaping the room by locking the bedroom door from the inside. This had raised the assumption that Dinas had the intention to murder her husband because she could have run out of the house without locking the bedroom door. And also, it was testified by Sarah that Nazlan is an impulsive person and had physically assaulted Dinas before. So there is a probable situation when Dinas had the motive to kill her husband with the easiest way. Dinas had the intention to leave her husband inside a burning room and subsequently cause him to die, judging by the several occasions suffered from the physical assault by her husband. Because it is unreasonable for a person who has zero intention or motive to kill someone to lock the door and not inform the person beside them in a dangerous situation. In conclusion, actus reus of causing death and the mens rea required is proven to coincide. Since causation can be established, Dinas shall be held liable for murder under Section 300 of Penal Code and punishable under 302 of Penal Code.
Thank you, Annabelle. As for my part, I will address whether Dinas' charge can be amended to an offence lower than murder. Since Annabelle had mentioned that Dinas can be charged under Section 300 sub B, the word intention in the provision itself carries a heavy interpretation and meaning. What if there are alternatives and possibilities that Dinas can be charged with? The fact that Dinas suffered from panic disorder, she has a high probability to be charged under Section 299 of Penal Code. In simple terms, all offences under Section 300 can be under Section 299, but Section 299 cannot be under Section 300 as the weight of the offence, such as murder, is more serious and heavier. Next, consider Dinas' situation at the precise moment where she is having panic disorder in which she does not fully have the right mind. This had been justified by the Diagnostic and Statistical Manual of Mental Health Disorder. Furthermore, if someone has recurrent unexpected panic attacks, and this will lead them to change behavior, which would act rash and careless. Applying the case of Emperor and Diraja, Dinas does have the knowledge that her action might have caused her husband to die. But in that situation, suddenly she got a panic attack from her disorder, and this attack caused her to be reckless. When someone is in a state of panic, facing panic attack or anxiety, the person may do things incorrectly. Not only that, we can refer to this issue as well with special exceptions under Singapore Penal Code, Section 300 of the Penal Code. In the exceptions, under the mental impairment specifically, it has been established regarding diminished responsibility defense whereby the accused must fulfill three conditions. Applying the case of Ong Pang Siew NPP, it's understandable that Dinas does not have any duty or responsibility towards her husband anymore at the moment when she is facing mental conditions. Lastly, applying back Section 304A of Penal Code and the case of Impress and Idubek, where it established the same principle. Dina's action of locking the door could be analysed in the context of rashness. For the same reason that has been explained before, when gets a panic attack, Dina can be rash without realizing what she is doing, and her rash act would make her unintentionally cause him to die without having any intention of doing him harm. That's all from me. Next, I'll pass the floor to Adisa.
Now, we are going to delve into the question of whether Dinas can raise the defense of accident for her actions, particularly in the context of Section 80 of the Penal Code. Section 80 of the Penal Code stipulates that an act is not an offense if it is done by accident or misfortune, without criminal intent or knowledge, in the course of carrying out an authorized conduct in a lawful manner with sufficient care and caution. To successfully raise this offense, four elements must be met. Firstly, Dinas must establish that the offense was a result of accident or misfortune. The legal standards define accident as an act that causes harm without the intent to harm, and Dinas' panic-induced actions leading to the fire could be argued as unintentional and unforeseeable. Dinas also contends that the fire resulting in Nazan's death was unintentional and unforeseeable, aligning with legal standards defining accident. This resonates with cases like R against Ong Chun, emphasizing acts causing harm without intent. The second element is that the act must be lawful and performed in a lawful manner. Dinas must prove that her actions were not only unintended but also carried out with due care, such as locking the door to prevent the fire from spreading, which is crucial for her defense, similar to public prosecutor against Abdul Khalid bin Abdullah, where accidental harm resulted from lawful conduct. Dinas's act of locking the door to prevent fire spread illustrates lawful actions taken with care. The third element is the accident must not be the result of criminal intention or knowledge. Dinas's panic attack, panic disorder diagnosis, and the circumstances surrounding the fire should be emphasized to highlight the absence of criminal intent on her part. Contrastingly, in the case of public prosecutor against Andal bin Arullah serves as a precedent where the court rejected the defense due to evident criminal intent. Lastly, Dinas must demonstrate that her actions were taken with proper care and caution. Her sealing the door to contain the fire could be considered as a reasonable and prudent response in a terrified state, showcasing the application of due care. To strengthen Dinas's defense, we also drew parallels between legal precedents such as Morilal against state and state of government of Madhya Pradesh against Ramdas Wali Narasimha Naidu, where the defense of accident was accepted under similar principles of proper care and caution in unforeseeable events. To summarize, this nuanced analysis of Dinas's case under Section 80 of the Penal Code and various case laws demonstrates that Dinas is able to raise the defense of accident.
The next issue is whether Dinas can raise the defense of unsoundness of mind against a charge. Section 84 of the Penal Code states that the act shall not be considered an offence if a person, due to unsoundness of mind at the time of the act, is incapable of knowing the nature of the act and that it is wrong or contradicting the law. Malaysian Penal Code's insanity defense, influenced by R against Angleton, differs from English law by not requiring a diagnosed mental illness. Instead, in Malaysia, there are several elements that the accused must meet in order for defense of unsound mind to prevail. Firstly, the person must suffer from unsoundness of mind at the time of committing the offence. In Pras Nimala Ratni against the Republic of Sri Lanka, the defendant charged with murdering his spouse raised an insanity defense due to prior epilepsy and erratic behavior. The court rejected it, stressing the requirement to demonstrate insanity at the time of the offence. Applying this to Dina's situation, her deliberate action during the fire incident suggests she may not meet the standards of her insanity defense. Secondly, the accused act must be the reason for the unsoundness of mind when committing the act. In Public Prosecutor against Muhammad Suhaimi Abdul Aziz, the psychiatrist concluded that the accused was not of sound mind when he murdered his wife by stabbing 26 times. The federal court upheld the insanity defense. Applying this to Dina's case, her intentional act of locking the door during the fire, coupled with her awareness of the potential consequences, suggests she was not of unsound mind, which means it is unlikely for her to be able to raise the defense of unsoundness of mind. Thirdly, the accused must be unable to understand the nature of the act due to the degree of unsoundness of mind. In R against Qadir, the court highlighted focusing on the physical, not moral characteristic of act. Dinas, aware of the potential consequences of locking the door during the fire, may not properly claim insanity even if her panic attack was caused by a diagnosed condition, as evidenced by her recent actions during the incident. Fourthly, the accused must be unable to perceive the wrongfulness or contradiction to the law in their actions. In John aka Nyumbe against Public Prosecutor, the court required the accused to prove unawareness of immorality and illegality for insanity defense. Despite arguments of panic illness, evidence in Dina's case suggests she knew that locking the door during the fire was against the law, indicating she may not be insane. In short, Dinas cannot raise the defense of unsoundness of mind against a charge. Thank you, and I will now pass the floor back to Daniel.
Alright, thank you, Rian. So now let's conclude our presentation. In a nutshell, Dinas is liable for murder under Section 300 and Section 302 of the Penal Code due to the coherence of actus reus and mens rea and the absence of a break in the chain of confession. Potential lesser charges such as culpable homicide under Section 299 or causing death by rash or negligent act under Section 304A remains plausible. Next, the defense of accident may be sufficiently established as her action did not seem deliberate during the incident. Dina's panic disorder might not fully meet the criteria for the unsoundness of mind defense. That is all from us, and that concludes our presentation for today. Thank you and have a nice day.